May it please the court and counsel, my name is Ryan Somatic and I represent the appellants in this matter, Daniel Harvey and Portia Harvey. I would like to request 4 minutes for rebuttal, please.
All right, sir. You may proceed.
This is an inverse condemnation action that was decided on summary judgment based on the defense of the statute of limitations. It was also decided on a truncated record where the trial court prevented discovery on matters plainly pertinent to the statute of limitations. The gist of this is that the plaintiff alleges that the defendants have flooded the Harvey home. And I'm asking the court to reverse and remand for a trial on the merits with standard broad discovery applicable for two major reasons. First, because when Harvey or a similarly situated plaintiff should have known that their injury was permanent is a disputed fact open to multiple interpretations that should not have been resolved on summary judgment on this record. And second, because the appellee's actions suggesting a fix of the flooding lulled Harvey into thinking that filing suit immediately was not necessary, to the extent that the defendants knew or should have known that their actions were lulling the plaintiff is yet another possible disputed fact that was inappropriate for resolution on summary judgment. Now, because this is a statute of limitations case, the major focus here is the starting point of the statute of limitations. And contrary to some other type of injuries, the start of the statute of limitations in this case is not just when the injury occurred, and it's not just when the plaintiff should have reasonably known when the injury occurred, but it's when the plaintiff should have reasonably known that the injury was permanent and not just some temporary problem. The applicable statute of limitations, by the way, for this case is 1 year. Now, I just want to give a quick timeline recap here. So there's two floodings of consequence. One was in January of 2013, and one was on June 29th of 2014. Now, after, I have to back up just a minute. The alleged cause of the flooding was the reconstruction of I-240 just outside of Memphis. And that construction was from around 2011 to 2012 and was not substantially complete, definitely, on this record until 2012, and therefore no notice could be given by the completion of the project until at least 2012. So the two floodings in January 13 and June 2014, after the first one, Harvey made the city aware that the flooding had occurred. And the city, being partially responsive to this concern, took an extraordinary step of commissioning an engineering report by Fisher and Arnold. And it's been referred to by the parties as the Fisher Report. And the Fisher Report was provided to Harvey in August of 2013. And I'll get into what that report was about a little bit later. But that is a critical event in this timeline because that is the item that the trial court said this document would have given any reasonable person notice that the flooding on your property was permanent as of that date, August 2013.
And why did the court find that? What about that document made the court find that that was the marker?
You know, I don't know. The court didn't come out and say that this particular sentence, paragraph, or finding within this report is what should have set any reasonable person on notice that the taking was permanent or that the injury was permanent. Because if you look at what that report was really all about, it wasn't just a status report or a documentation of the status quo. In other words, this is the drainage situation on your property, please take notice. That's not what it was about. In fact, if you look at the scope of work in there, and what the Fisher engineers actually did, it specifically says that the report, the scope of work was commissioned for possible mitigation of drainage concerns within the Harvey's greater subdivision. Not only that, but there were two improvement scenarios that were proposed in the report, both of which would provide more protection to the Harvey's property and the entire subdivision. So much protection, in fact, it would protect them from all floods except the most extreme 100-year storm. And even in those events, the home itself would not be flooded, according to the Fisher engineers. So I don't know how receiving a report that says, hey, the intent of this report is mitigating your drainage problem, here's 2 possible solutions, how I'm supposed to look at that and say, oh, my problem is permanent, no one's ever going to fix it. If either of those 2 scenarios proposed in the Fisher report were reasonably probable, or a person reading that would reasonably think, if either of these is affected, I'm going to be okay, then it couldn't possibly have given notice that the problem was permanent. It was a temporary problem at best.
Were any of those remedial actions taken?
They were not, although even after the Fisher report was issued, there were subsequent actions by the city telling Harvey that they were taking actions to both remediate the long-term drainage situation in their subdivision and also taking actions to cure what they called the low-hanging fruit or short-term drainage improvement within the situation, within the subdivision as well.
Were those remediation efforts consistent with what the report suggested needed to be done?
They didn't, were they implemented? Is that what you're asking?
Well, you said that there were some actions taken to try to do something about the flooding. Were the actions that were taken consistent with what the report suggested needed to be done?
Well, as an engineer and with no testimony about that on the record.
That's not in the record then?
No.
Okay.
There's no engineer that says, because we haven't got to the merits of this at all. I've been prevented from taking discovery on the merits and even on matters pertinent to the statute of limitations. So we're just not that far along. What I can tell you is that after the Fisher report was commissioned and the city was in the process of trying to find solutions to the drainage problem, they remodeled or attempted to remodel the data used in the Fisher report to create similar improvements, and one that they called an option C. Recall that were 2 options in the Fisher report. This is option C, or number 3, consistent with that same data. So were the projects actually get done? No, because if they were, we probably wouldn't be here. But did the city take actions consistent with what was proposed in the Fisher report? Yes, I think so. And some of those would have been preliminary type of actions, like surveying and clearing out the area, which the city said they did to clear blockages to allow for better drainage and to allow for additional capacity of water to be stored, hopefully thus not dumping it into my client's house.
Does the record contain any evidence that the city told your clients that they were trying to remedy the problem?
Well, I'll just read from the, first, yes, there is, plenty. And it's all cited in the facts section of my brief. There was many situations where they said they were looking to alleviate, fix, remediate, mitigate, etc. But you don't have to take my word for it. Right in the table of contents of the city's brief, it says, argument 1D, the city told appellants that I was working on potential solutions to the flooding. So there you go. It's not just my characterization of it. The city admits to the same thing. Now, I think it's important to pull at least a bit of law in here. One of the cases cited by both parties is Knox County versus Monsier. And I think one of the critical points in there is that case stresses that when you're trying to determine the reasonable knowledge of a plaintiff as to when the injury is permanent, the context that is surrounding the plaintiff, including representation from the government, are critical. So in that case, the plaintiff was complaining about a flooding on their property caused by a government project, and the government agent said, hey, don't worry about it. We're working to fix this. It's going to be a temporary thing. We're working to alleviate the problem. And the court there said that when the government is making such representations, it's reasonable for a plaintiff to rely on those and conclude that the injury is not permanent, at least not at that point. There may be a point when those representations turn out to be bogus, and any reasonable person should realize that they're bogus and sue, but while they're telling you we're going to fix this flooding problem, it's reasonable to think that it's temporary, and those should be considered. Beyond the representations of fixing the flooding, I think another critical point here is that the city, unprompted by Harvey, referred Harvey to an agent that was working with FEMA, Federal Emergency Management, on a potential buyout of the Harvey property. Now, if there's a buyout of the property, well, your problem goes away. Not only that, but as it pertains to equitable tolling, which I might not have time to get to, it is sort of the ultimate lulling or inducement that you don't have to file suit because my property will be purchased, I'll no longer have flooding, and none of this matters. Very briefly on equitable tolling, which can shift the statute of limitations back or pause it while the plaintiff was being misled. It's important to understand that there are no bad acts required. The defendants do not have to intend to mislead the plaintiffs. It's just whether they knew or should have known that their actions would cause a reasonable plaintiff to delay filing suit. I see I'm out of time here, so I'll just wait for rebuttal. Thank you.
You still have your rebuttal time of 4 minutes.
Morning, Your Honors.
Good morning.
May it please the Court, Will Perry of Butler Snow LLP in the Memphis Bar. I'm here with my colleague Lauren Jones for the defendant, Appellee, City of Memphis. With the Court's permission, I will take 10 of defendants' 15 minutes, and the remaining 5 minutes will be argued by counsel from Memphis Light, Gas, and Water.
Okay. That's Mr. Jones.
That's Mr. Strain, Your Honor. Ms. Jones is my colleague here with me.
I'm sorry.
Thank you, Your Honor.
I'm a little confused here today.
Your Honor, plaintiff's claim for inverse condemnation is just as untimely today as it was 4 years ago when this case was last before this court. In 2019, this court affirmed summary judgment for the state of Tennessee, holding that plaintiffs, quote, did not file their claims within the applicable one-year statute of limitations under Tennessee Code Annotated Section 29-16-124. This court vacated the trial court's grant of judgment on the pleadings for the city and Memphis Light, Gas, and Water, stating that their motions should be considered in the same posture as the city's under Rule 56 rather than Rule 12. So on remand, the city and Memphis Light, Gas, and Water followed this court's instructions and successfully moved for summary judgment. You've read in plaintiff's briefs and heard today some things that I'm compelled to tell you just aren't in the record. Terms like remediate, cure, and low-hanging fruit are creations of the plaintiffs. They are in the plaintiff's affidavits, to which are attached emails between Mr. and Mrs. Harvey. They are not correspondence from the city. What is in the city's brief and in the factual record here is what the city actually told the plaintiffs, and that is that it was looking for potential solutions to the flooding. That is different from promising a fix, and that's certainly different from promising a cure. As before, it is undisputed that plaintiff's home in Memphis flooded 3 times, not twice. In August of 2009, in January of 2013, and in June of 2014. Plaintiffs did not sue for any alleged damages until June of 2015, which is 6 years after the flooding first started. Now, as before, it is undisputed that plaintiffs attributed all 3 floods to the I-240 construction and that they reported all 3 floods to the state of Tennessee. It is unclear whether and to what extent plaintiffs also reported the alleged flooding, the flooding to the city, Memphis Light, Gas, and Water, and Shelby County, whom they also sued. Now, as before, and this is the critical point. It is undisputed that in between the second and third floods of plaintiff's home, in August of 2013, plaintiffs received a study commissioned by the city of Memphis about the flooding. And again, I must tell you, the study was in fact a review of the drainage conditions at plaintiff's property. It is clear from the record why the trial court found the study in connection with the two floods that already had occurred by the time plaintiffs received the study was enough to have put the plaintiffs on notice that their problem was permanent.
And what would that be?
Yes, Your Honor. First, the study's stated primary purpose, and this is in volume 1 of the record on page 22, was to, quote, perhaps mitigate or at least reduce the flooding on plaintiff's property. Flooding had been a problem on plaintiff's property dating back to the 1970s, almost 3 decades before plaintiffs purchased the property in 1997. The study stated that the city had tried and failed to reduce the flooding in plaintiff's subdivision dating back to the 1980s. Second, Your Honor, the study said nothing about eliminating flooding in plaintiff's property. Plaintiff is correct that the study identified 2 scenarios that could potentially reduce, but not eliminate, the flooding in plaintiff's property. Scenario 1 was inconsistent with Memphis Light, Gas, and Water's grading requirements. And scenario 2, the study, quote, did not recommend the additional work shown and analyzed because it was too expensive. All of that information is in the study, and that is why, in connection with the study, the second flood in January of 2013, and the first flood in January of 2009, the trial court was able to find that plaintiffs were on notice that their flooding problem was permanent.
What was the conclusion of the study, or did it have a conclusion?
The conclusion, to the extent that there was one, was that historic flooding problems had plagued the plaintiff's subdivision for nearly 4 decades, and that the 2 scenarios that could be identified that would, again, potentially reduce but not eliminate the flooding were, 1, either inconsistent with Memphis Light, Gas, and Water's grading requirements, or 2, too expensive. And the study itself says it did not recommend that second study.
So did it recommend anything?
No, Your Honor. The study was an analysis of the circumstances and what potential solutions there might be, those potential solutions being limited to the possibility of reducing rather than eliminating the flooding in plaintiff's subdivision.
So the study identified the problem, proposed 2 potential solutions, and then said that neither of the 2 potential solutions should be pursued.
That's correct, Your Honor. And also, the potential solutions did not promise to eliminate the flooding. They were potential solutions for reducing the flooding, which again underscores the fact that plaintiffs were on notice that their flooding problem was permanent. In 2019, this court stated that in reviewing the evidence in the light most favorable to plaintiffs, it is clear that plaintiffs knew of the permanent injury to their property at least by June 29, 2014, when their property flooded for the 3rd time. The court expressed no opinion as to whether plaintiffs had sufficient knowledge at any earlier date. You heard Mr. Sematic tell you that the plaintiffs didn't know any earlier than 2014, but they've never been able to explain to this court or to the trial court what they knew in 2015 when they sued that they didn't already know in 2014 or in 2013 when their home had flooded twice and they'd received a study that could not identify any way to stop it.
So after the study was entered, or after the study was presented to all involved parties, what, if any, action did the city take?
There is no action reflected in the record by the city, except that the city continued to look for potential solutions to the flooding, as it told plaintiff, as recited in plaintiff's complaint and now in the summary judgment record. Each time the plaintiffs experienced a flood, the city said, "We are looking for potential solutions." And as you know very well, Your Honor, from your decision in Boyce, telling the plaintiff that you're looking for a solution or even being silent or taking no action is not sufficient to invoke equitable estoppel, which I'll get to in a moment. Plaintiffs unduly emphasize their subjective knowledge of the permanency of their problem, but the subjective component is only half the battle. This court has stated very plainly, Judge Golden, in your 2015 opinion in the Bobo case, that inquiry notice is sufficient to start the running of the statute of limitations. More recently, Judge Stafford, in 2019, in the Little opinion that you offered, this court stated, quote, "An inverse condemnation action accrues when the plaintiff realizes or should reasonably realize that his property has sustained an injury that is permanent in nature." In response to these undisputed facts, plaintiffs say that the city should be stopped from relying on the statute of limitations. First and foremost, that argument is waived, as this court held in 2019. Plaintiffs never raised it in response to the city's motion for judgment on the pleadings. They therefore waived it for purposes of their first appeal, and that waiver is now the law of this case for this appeal. But in any event, plaintiffs never have alleged any inducement by the city not to sue. They've never alleged any deception by the city, and the summary judgment record does not disclose any deception. An unbroken chain of decisions by this court and the Tennessee Supreme Court in such cases as Red Wing, Farner, Boyce, and Haidt, all of which were cited in this court's 2019 opinion, require that plaintiffs must establish both false representations or concealment of material facts and the intent to induce plaintiff not to sue. They must have both of those elements to establish equitable estoppel. And as this court knows from the decision of Paducah versus City of Johnson City, the standard is even higher when the defendant at issue is a public entity. As the Tennessee Supreme Court stated in Paducah, public agencies are not subject to equitable estoppel to the same extent as private parties. I see that my time is about to run out. I'll rest on my briefs in response to the plaintiff's arguments about the denial of their motion to compel. It was discretionary, and the plaintiffs identify no error in the trial court's decision in their briefs. Thank you, Your Honors.
Thank you.
May it please the court, I'm Ryan Strain, Baker Donaldson Law Firm in Memphis, representing the defendant Appellee Memphis Light Gas and Water Division, which I'll refer to as MLGW. MLGW and the city's positions on appeal largely track each other, so in an effort to avoid duplication, I'll use my time to focus on issues that are slightly different or additional arguments that we've made. First, it's important to note that the city and MLGW are separate defendants and separate entities. The briefing, certainly the appellate briefing, plaintiffs often lump the two parties together and are not precise about which party did or acted in one way or another. Statements made or actions taken by the city are not statements made or actions taken by MLGW, and vice versa, of course. Just as one example, MLGW did not commission the Fisher report. Second, plaintiff's sworn testimony that work began in 2008 and that plaintiff's property was flooded in 2009 certainly can be considered by this court determining whether their lawsuit was timely filed. Due to the other statute of limitations triggers discussed by Mr. Perry, court certainly it's not necessary for the court to determine to consider those, but it certainly can. And additionally, as Judge Golden stated in his Bobo case, factual variants in the pleadings are conclusive against the party unless they are amended and withdrawn, neither of which has occurred in this case. Plaintiffs muddle the discussion of the Tennessee Supreme Court's Monsier decision. Monsier instructs that in the case of flooding allegedly caused by a public improvement, that injury is permanent at least by the time a substantial part of the construction is complete and subsequent flooding has occurred. You heard Mr. Sematic admit here, and they did in their briefs also, that construction was substantially complete. In fact, it was complete in April of 2012, subsequent flooding in January of 2013. Monsier is also notable for purpose of this case about what it says about discussions from government entities after that point in time. In Monsier, a substantial part of the roadway construction at issue was complete in September of 1964, and there was subsequent flooding in January of 1965. However, even assurance is given by the state engineers after January 1965 that the problem would be alleviated, did not toll the statute of limitations. Here, plaintiffs' sworn allegations, undisputed material facts demonstrate again that the construction that they blame for the flooding of their property was complete in April 2012, subsequent flooding in January of 2013. They've, again, sworn allegations that they notified government parties of the flooding and that their belief that it was caused by the I-240 construction, more particularly at the construction of a detention basin on the west side of I-240. They've also alleged in their sworn complaint that each flood significantly decreased the property value, which is a hallmark in Tennessee case law of a permanent injury in an inverse condemnation matter. And again, as Mr. Perry discussed in detail, the August 2013 Fisher and Arnold study that they admit they received in August of 2013. Due to time restraints, I'll rest on my brief as far as responding to the arguments on the contrary of the statute of limitations and why those should be rejected, although I did want to note a couple of things. First, the Fisher and Arnold study did acknowledge that the first proposed solution depended on MLGW's support. Again, MLGW did not commission that study, and that proposed solution entailed going against what MLGW customarily allowed. Additionally, MLGW, I don't even know if we heard the name MLGW spoken by Mr. Sematic other than identifying us as a defendant. MLGW made no representations that would have led a party to believe that they were working to do something to alleviate this issue. Their mere presence at a neighborhood meeting at the plaintiff's invitation where they did nothing more than greet the plaintiff certainly doesn't provide a basis for that. Sixth, it's important to note, as this court recognized in its earlier opinion in this case, that equitable estoppel is applied on an individual basis. MLGW doesn't believe that any of the city's actions provide a basis for applying equitable estoppel, but certainly none of the city's actions should be considered in applying the doctrine to MLGW. Plaintiffs argue that equitable estoppel doesn't require intentional bad acts. That's contrary to this court's opinion in 2019. Additionally, as of September of 2013, MLGW had conveyed a permanent drainage easement to the state, conditioned on the state handling complaints regarding the installation of the detention pond. Finally, the motion to compel the plaintiffs filed was sought documents and information from the city, not MLGW, has no application to the summary judgment motion and briefing against MLGW. Oh, and I'm sorry, apparently I've gone over.
Thank you.
Thank you.
I believe you have 4 minutes.
Thank you. Just get right into it. Let's start with the facts in the case and whether the source of that is simply my clients or whether they're in there satisfactorily as far as the appellees are concerned. I think that's a rather disingenuous argument to make because I was completely prevented from taking the depositions of the relevant city agents where their admissions could be obtained to substantiate exactly what my clients are saying. They might dispute what my clients are saying, but because discovery was prevented, my client's statements about myriad facts are unrebutted at the very least. Regarding the 2009 flood, as Mr. Strain correctly said, you can't get notice that a public project caused flooding until it's substantially complete. Well, it wasn't substantially complete until 2012, the project, and so a flood commencing before that project was ever conceived of can't give notice of anything other than that there may have been an act of God that made the ground particularly wet that day. It doesn't pertain to notice of completion of a project that could have exacerbated the flooding situation.
What about the information that this area had been flooding for decades? In other words, this was not something new, and it may have been exacerbated by the construction, but it wasn't that this was an area that didn't flood. Apparently, it had been flooding for decades.
Well, not since, well, there's several points
The
there.
70s.
Sure, several points, Your Honor. It wasn't so wet that the city declined to approve residential development in the area. Also, as far as the exacerbation comment that Your Honor made, if it did exacerbate it to the point where it went from I have a soggy lawn once in a while to my house floods all the time, that is a new action that would give rise to what was not a taking, i.e. a wet lawn, to what is a taking, substantially devaluing the property and flooding the home itself.
Well, the issue, though, is statute of limitations.
It is.
What you knew or should have known. In other words, even in the condition that with the homes being built and whatnot, it flooded 3 times, as I understand it. Is that right?
The 3 floods are 2009, 13, and 14, but the plaintiffs had owned it since at least 1997 with no floods until 2009. But, I mean, what it could tell you, first of all, you could disagree with all of the background nitty-gritty of that report and still look at it and say, well, the purpose of this report is mitigation of what's happening in my subdivision. Therefore, I disagree with the fact that this has been a flooded area since the 1970s, since I've lived here, and it's reasonable for me to observe my surroundings, and yet take note of what is the purpose of this report being provided to me, to better my situation irrespective of what the background facts may be. And I think that goes into the exacerbation argument too. The report didn't say the I-240 project did or didn't flood your property. It just said this has been a challenging drainage environment for a long time. Fine, but not so challenging that we haven't lived here for a long time without any problems. And just briefly on that Fisher report, the first scenario said it needed MLGW cooperation. So what? That doesn't mean that it's not forthcoming or that MLGW wouldn't cooperate. In fact, they initially thought that the proposal was reasonable before changing course. Secondly, the second scenario was only not recommended because it was $24,000 or roughly 10% more than the first ones with only marginal better protection. However, knowing that MLGW's consent was not forthcoming on the first one, it would have been equally reasonable to think that just a minor increase in costs would have been reasonable for the second scenario. Thank you.
Thank you. Thank you, counsel. We appreciate your argument. We will take this matter under advisement and attempt to render an opinion at the earliest possible time. Thank you.
Thank you.
You may be excused. We're going to take a brief recess, and we'll get the next case up and ready to